recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Hey, Paul, how are you?
Oh, just wonderful. Making preparations for my Christmas party.
Oh.
I doubt they would let you on the visitors list here.
No.
You speak evil of the royalty of Connecticut, so they won't let you in.
Listen, I think that Mukasher's gotten okay when he went to Newsweek. His stuff is entertaining. You know, he writes articles. You know, and the fact that it's in Newsweek, but it's it's okay. It's not that it's not as not terrible. It's actually pretty insightful. So he's gotten better. I think a lot of these people would be better people if they got off the bench.
Say what?
A lot of these people with judges might become better people if they got off the bench.
Oh yeah, no, definitely. Well, speaking of which, I have plenty of time to read, and I got copies of some old cases, and one is Roth. I guess it's Roth v. U.S. R-O-T-H. It's back to 1957, and it was really based on these obscenity laws, But there was a lot of, interesting stuff to read in the dissents and the concurring opinions. But anyway, and I'm trying to remember. Actually, I think it was in the opinion by Brennan, where he quotes the Continental Congress from 1774 in some letter to the people of Quebec, talking about the basis of the freedom of speech. And there's a line in there that basically says, it's a fundamental liberty interest, and, its purpose is to intimidate and shame public officials into more honorable service. And I thought that was amazing because, you've got all these, anti-intimidation statutes on the books, and here it was the Continental Congress saying, no, we want the people to be able to speak for the purpose of calling out officials and get them to do a better job. And actually, I think the word is a more honorable service, but the words they use are intimidate and shame. And of course, we have a federal statute now that you can't write anything that a judge would think is intimidating. But we don't have a state statute for that, so I'm fine. Don't worry. And oh, by the way, on Mukasher, I hope you can know how to connect the dots. Okay. His book was published by Brandeis Press, and you know what Brandeis University is.
Yes, of course.
And you know who Brandeis is.
I know who Brandeis is.
Okay.
Yes, we've had conversations about Brandeis and the laboratory of law and all that other stuff, the other fun stuff.
Where did Joette Katz go undergrad?
Did she go to Brandeis?
There you go.
Wow.
She's a Brooklyn Jew. She went to Brandeis, and she went to UConn.
Well, I have a soft spot in my heart for Brooklyn Jews. Come on, I'm a Staten Island kid.
I can't hear you.
I have a soft spot in my heart for Brooklyn Jews. I'm a Staten Island kid, but that's neither here nor there. There are conservative Brooklyn Jews, and there are liberal Brooklyn Jews, and there are all different types.
No, I got it. Hang on, I'm not finished. I'm helping you connect the dots.
Okay.
Okay. All right. Now, Mukasher didn't retire because he wanted to. Something was going on. All right. I mean, he only had 10 years on the bench, and he was supposedly this savior of the judiciary, and he wrote some pretty fucked up shit. He took that case where they challenged funding of public schools in Connecticut, and he took it on and he granted it, and the appellate court snatched it as fast as they could and tore it up, and then he was kicked off the civil docket, the complex litigation, and he was banished to family court. and then he fucked that up, and he got lots of attention, and then he retired. Okay, because they basically kicked him out of there too. And in return for him disbarring Kuna, because Kuna called out the Jews of family court, he was rewarded. So he got his retirement, he got a book, and then how does Newsweek find Mukauser? A frickin' nobody with very limited judicial experience, living in a corner of Connecticut. He's obscure. Next thing you know, he's writing for Newsweek. Look at who Katz's husband is.
Who's her husband?
That was, huh?
Who's her husband? The guy.
I can't hear you.
Who is Katz's husband?
Hang on. Try again. Can you
talk
closer to the mic?
Who is Joette Katz's husband?
Oh, you gotta look it up. I can't explain it, but he's this very weird guy. Something has his own lab in speech pathology or something, a PhD in something, and he's a White House. Well, it says he was a White House fellow, but I don't know when. Now you can dig into that. I mean, how do you think Katz made it to the Supreme Court of Connecticut? It wasn't because she's a great jurist. I mean, she's literally hated by people in Connecticut. And the reason she resigned from government when Lamont got elected is because she knew he was going to boot her right out the door. Okay? So anyway, believe me, Mukauser is not a guy that Newsweek wants. Newsweek, and you know who owns Newsweek, by the way. So, anyway, so I just wanted to pass that on to you. But I want to get back to the issue of, did you have any time or put it on your list to think about the jurisdiction?
It is on my list. Your papers are on there. I'm going to probably run something about that. I'm probably going to talk about it tomorrow with Volpe on our podcast, and then put out a little bit more about that. But yeah, that's in the docket right now to talk about now. The big thing I want to talk about though, and not after jurisdiction, is going to be the bail hearing coming up. That's the big the new piece of news.
I don't think it's coming up. I wanted them to file that thing right away. They asked for an immediate hearing, and I don't think they did it. And so I think I'm just stuck here for another Christmas and New Year's because, quite honestly, it doesn't seem like these new clowns are moving very quickly. All they can tell me is, oh, you're not my only client. Oh, this is going to take time. Oh, this, that. And I'm like, I would like you to do this and this. It would take 10 minutes to type it up. No, they won't do it. And so I think there's a hearing on the 3rd of January, but that's scheduled before Brown. And forget it. Brown is a goddamn idiot. And I said, look, if you don't get a hearing before Harmon, it's a waste of time because Brown is not going to give me a promise to appear. Brown thinks there's some great criminal element of free speech, and he's a moron. He's already denied every motion I filed, and so that's the answer on that. And if we go to Harmon, maybe we have a chance because Harmon was the guy who said he's spent enough time in jail, and so there's no reason to keep him in jail if he's already spent enough time for whatever plea. But I mean, come on. They're reporting to somebody. So you think they're going to let me out? No. And the other thing that you should write down is when the bond reduction was discussed in chambers with Kelly and Doyle, and I think it was Judge Brown. Doyle said the state was going to move to raise it. Now, the thing to write down under there is it has to be good faith. Well, Doyle doesn't have any reason to raise the bond. I mean, but that's what he told the judge. He said the state's going to move to raise it. Bad faith? Again? Really? Doyle? Yeah. Somebody's telling him what to do. Don't let him out. And we're just going to keep him in jail. We're not going to schedule a trial, and then we're going to get him to plead guilty and see we won. The Jews got their pound of flesh. So, anyway, there you go. That's all the news is fit to print.
Okay.
And so, otherwise, but yeah, I had fun chatting with it, and I mean, this is. Oh, one last item, right on the word discussion. I think it was in Roth, or it might have been in Pope v. Illinois, and they talk about discussion. You know, the First Amendment protects discussion. So you can discuss anything in politics as First Amendment protected because it's a discussion, and it's essential to the republic. So if you're discussing bad things happening to bad public officials, that's First Amendment protection. You can't slap a truth thread on top of that. But anyway, there you go. See the things I pick up when I'm doing nothing but staring at a gray wall in jail.
Yeah, it's very true. So.
Yeah. So anyway, there's some good stuff in there. But all right, well, have fun chatting with Mikey and the rest of the world.
All right, I'll get it out there, and yeah, we'll get some stuff on the jurisdiction and the yeah, and the fact that I don't think he should have been taken out of Virginia, or it's questionable at the very least, and that issue hasn't been resolved by the courts. So. Yeah, there's a lot of federal issues. You hearing anything from the Second Circuit, or they're moving at a snail's pace?
Oh, we know all the issues. And one last thing. You know, I gave Kelly permission to talk to Volpe, so I'm suggested Volpe make his inquiries.
I sent her questions too. She hadn't responded to me, so.
And you can tell her that you talked to Paul, and Paul said, "Go ahead, talk to Rich."
Well, she's never gonna do that without it coming from you directly. So.
Yeah, well, then tell her to come to jail. Talk to me. I haven't been able to get in touch with her last week. They just bounced me into her voicemail. I don't think she wants to talk to me because I think she's already been told what's going to happen. And so.
All right.
There you go. Alrighty. Well, we'll catch you later. Good
All right.
to hear from you.
All right. We'll talk to you later.
Thanks.
To register this number as a private number, to accept this free call, press 1. To refuse the thank you for using Securus. You may start the conversation now.
Hello.
Good morning.
Hey, how are you? What's going on?
Phone problems yesterday. Well, sounds like this Kelly Billings is a twin sister of the Jen and Alice team. Good God.
What happened so far?
Say what?
What's happened? What makes you say that?
Well, they finally got the motion to reduce bond filed, which took them ridiculously long amount of time and lots of arguing. Evidently, I told them, well, why don't you just put in a little note that the Constitution says no one shall be arrested or detained unless clearly warranted by law, and since I've been in jail for 520 days, it's not really clearly warranted what I did yet. And then she refused to put that in. And I said, why not? I said, throw in the kitchen sink. Who fucking cares? She had to give me a lecture. I'm not a lawyer.
Well, wait a second. Well, she gave you the lecture. She's not a lawyer, but did she explain to you why she couldn't put that in to zealously advocate for you?
She made some excuse that it wasn't one of the criteria mentioned in that case, Quincy and Pan v. State. And I said, it doesn't matter. There's nothing that says you can't put it in. And then, I finally said, look, I'd like you to put it in. She said, no, I won't. And then it got even worse is yesterday I'm talking to her and she said, well, she explained to me, that she had asked for the hearing, that Doyle exploded, and there's some string of emails back and forth, and she was trying to convey how shocked she was. And I'm like, look, kid, this is the big leagues. If that's going to shock you, you need to get off the case. And I even told Volpe about it, and I told Volpe to ask her for the email, and she refused to give it to him. But I guess she gave him the motion to reduce fund. And then I said, look, you got to get this hearing before Harmon, not Brown, because I already filed a motion to disqualify Brown, so we're not going before him on anything. And evidently, sent an email to Harmon. Harmon got involved and said, no, the motion's going to go before Brown. And then I said to her, well, you need to tell Harmon that your client filed a motion to disqualify Brown. And she said, no, I'm not going to do that. And then I said, well, look, you need to send a note to Brown or to Harmon, the pretrial judge, saying you need a status conference because you just came on this case and it's a mess and you can't proceed and you can't provide assistance and you've got so many constitutional issues that Harmon needs to know about because then maybe he might want to do something about it. And she refused to send that note to Harmon because evidently, she can send an email right to Harmon. It's no big deal. I said, okay, fine. You got to tell him what's going on. But anyway, so that's the reason I'm trying to reach out to you because now the game is, well, it's going to be a hearing on the 3rd of January, so I'm fucking stuck here for Christmas and New Year's again. And when you talk to her, I'm like, Kelly, I've been in jail 520 days. I said, am I facing 3 trials or 1? You don't know. The court doesn't know. Nobody's even ruled on that, but they ignore it. But Jack wants 1 trial. And I said, that's not going to happen. And I said, discovery's not complete. And then she goes, oh, what do you mean? And so I listed the things. And I said, look, I filed a motion. After Jen and Alice left, I filed a motion that said, discovery's not complete. Here's what I need. I said, why don't you read the motions I filed, Kelly, and then you would understand what's going on. So anyway, now she's going to have to meet Dennis, and then she'll schedule a time to come talk to me in jail. And I'm like, you know how many times people say that? Oh, we're going to talk, and then we're going to talk, and nothing happens. I say, Kelly, you don't even have a plan. And, oh, by the way, I sent her a note, and I let her, and I basically said, I said, if you go off of the billing of the Jen and Alice shit show, I said, they burned about 1,200 hours in a year. And I said, that's about 40% of Kelly and Dennis's time for a year. And they keep telling me, oh, well, we don't have time to do all that. This will all take time. And I'm like, well, then you can't handle the case. And that's just insane. But anyway, I guess the purpose of the call was if you found anything under that clause in Article 1st, no person shall be arrested or detained unless clearly warranted by law.
Yeah, what it does is it basically enshrines all the criminal procedure rights. So that's really all it is. It's an additional bolstering.
Hang on. Are you on a speakerphone? Because I really can't hear you well.
I'm talking to you. Can you hear me now?
Yeah, it's better.
Okay. So what it is it basically doesn't create any additional substantive rights for you, but it's more of a procedural right that basically it brings to the forefront any other substantive rights that you have. So if you understand, you understand that?
Is there any case law on it or any explanation?
Hold on. Let me see what we got.
Because they keep trying to tell me that, there was probable cause because Gold's, scribbled his illegible signature on the arrest warrant application. And I said, I didn't see anything in that application other than a bunch of protected speech on political issues. What was the probable cause for arrest? There wasn't any mention of somebody lying in wait, acting in a predatory manner in a physical form of stalking. I mean, they don't get it. They just laugh and smile. They're all working for the judge and the prosecutor.
That's true. So, let's see.
Anyway, I don't want to get off the track. What I'm really looking for is something that maybe you and Mike can deal with to basically say that Connecticut is operating outside of the law. And then
The language of our present due process clause can be traced back as far as the mid-17th century. The Statutory Declaration of Rights was first enacted in 1615, provided that no man's person shall be arrested, restrained, banished, dismembered, nor in any ways punished unless clearly warranted by the laws of this state. Statutory Declaration of Rights, Article 1, Public Statute of Laws of Connecticut, 24, 1808. Our first formal Constitution of 1818 incorporated this principle by guaranteeing that accused shall not be deprived of life, liberty, and property, but by due course of law. And I'll give you have a pen there?
Say what?
You have a pen?
No.
Okay. It's State v. Morales. Okay, and that's 232 Connecticut 707. That's the site that you want to look at, which the Supreme Court case that talks about a lot of this stuff.
So it talks about it, and what's the name of the case again?
State versus Morales, Morales, 232,
What year was that?
1995.
Oh, okay. So, I mean, so it says in there what? It's due process.
It discusses the history of that section.
Okay, it gives it a history of it. But, I mean, the issue is the word clearly. It's not clear.
Yeah, but you have to understand. You have to understand the due process, what it basically where it comes from. So they what they do today is they say it's basically a due process clause. It's like procedural due process is how they treat it. But maybe you could make the argument based on Morales, based on there's another case called State versus Santiago, which is 2015, right? That there are actual substantive rights there that are being ignored in your case and that are part of the Connecticut Constitution based on Morales and on Santiago.
Yeah, those are more recent, but they're just mentioning them as historic things, right?
Yeah, but you want the historic things because it goes back to 1650, the Statutory Declaration of Rights, which was substantive. Back in 1650, there was a substantive right not to be arrested, restrained, banished, dismembered, or in any way punished unless clearly warranted by the laws of this state. In 1650, it was a substantive right, and it doesn't look like you're getting any. They're paying any lip, even any lip service to the substantive right that's been on the books since 1650. They're ignoring it, and they're clouding it by other rights that are ancillary to the real question of why the hell you've been arrested, restrained, banished, dismembered, and punished. In violation of the Declaration of Rights of 1650. And then again, the Declaration of Rights of 1808 and the first formal Constitution of 1818. You have three ancient documents in the state of Connecticut that are being run roughshod over by your prosecution. That's the argument I would make if I were you.
I got it. But the connection I want to make, and you got to understand, you're dealing with imbeciles here, is to say, okay, we're going to take the literal wording of the Declaration, and it says clearly warranted. Now, that means clearly, okay? And it says arrested or detained. Okay, I'm not even going to go after the arrest. Why is he in jail? Okay, why is he being detained in jail, and what's clearly warranted? Because right now we got Hartman and Brown and Doyle who haven't even declared what I did wrong. And the governor of Connecticut claims I committed a criminal act in Virginia, but nobody knows what it is. So I'm just sticking on the clearly word. Now, maybe you can take a couple notes on that and call Dennis, because supposedly Dennis was the guy who went back and looked at it and then told Kelly something, and she just blew it off and said it doesn't matter. Because I get nowhere with these people, okay? And, and Sonny even says, they've already been told. They've already been told they're not going to do anything for you. And, it makes sense. I mean, Joanne Katz ran the Office of Public Defender before she went to the Supreme Court. And, Connecticut's a small place. So, but my point is look, if they're going to write it in their Constitution and ignore it, then light it up, will you please? I mean, they don't have the jurisdiction to even have it here. arrest anybody they want in any state in the country based on somebody's hurt feelings in Connecticut. Give me a break. And so anyway, that was the purpose of clearly. Maybe you or Mike can send a zinger to Kelly because she's just not doing her job, just not doing it, refusing to do what the client asks. And I know what's going to happen. Oh, by the way, I think I told you, Kelly had said something in chambers with Brown and Doyle that she'd be moving for a bond reduction, and Doyle says he's going to move to raise the bond.
Yeah, I know.
Good faith basis, but again, it's just
you have
Doyle.
1 minute left.
Yeah, I'll call you back. It's just Doyle being a fucking prick doing the ADL billing, bidding, and
maybe he'll run into justice. Maybe Cash Patel will clean stuff up. Pam Bondi clean stuff up. You might get some looks that way.
Say what?
Maybe the new administration will come in and you might get some play on the federal level.
Oh, come on. Look, no. That is not a strategy, okay? Hope is not a strategy.
Oh, no, I know hope is not a strategy. You got to make your arguments, and you got to put them in.
The administration cannot, listen to me, nobody can touch Connecticut, all right? It's a Democratic bastion of pedophile, all right? And they got as much dirt on the new administration as the new administration might have holy hopes for the rule of law, okay? So that isn't the way it works in Connecticut. You don't know what this place is about. You don't know the players. You don't know how evil the
Thank you for using Securus. Goodbye. Thank you for using Securus. You may start the conversation now.
Hey, you there, Paul?
Yes.
So you were telling me about Connecticut. What's going on with this? I've heard that it's a ring of pedophiles. I heard it's the Democratic Party pimping out children, cash for kids. I've heard all of this stuff. I've seen some of it. You think that Connecticut is an insulated bastion and there's not even any rule of law? Is that what you believe?
No, and it's by design. I mean, why do you think the pedophiles come here? Because the judiciary, the law enforcement, FBI, U.S. Attorney's Office, Attorney General, everything is designed to protect them. Okay? And, there's been stories over the years, there was some guy in the FBI, got transferred, got a promotion, came to Connecticut, thought he was going to make a name for himself, and, he basically goes to the office and his colleagues are sleeping, and he tries to do something, and basically ended up getting fired because he tried to enforce the law. I mean, look at who the U.S. attorneys have been. I mean, the U.S. attorney right now, is this black bitch who used to work for the Attorney General's office of Connecticut. And you look at the structure under the U.S. attorney's office, or in the U.S. attorney's office. I mean, the head of criminal, he's a Jew. You dig down through the org chart, you can see all these other Jews, strange people who've been there for years. They had a civil rights guy who was there for years, and they never, ever brought a civil suit against, or whatever you call it, a federal civil rights suit anywhere. I mean, his job was to make sure that he didn't do anything. And, I mean, I can go on forever, but, the FBI raid in 2017, I mean, the reason that came down was because they went, the judges went to the state police. They went to the state's attorney, Kevin Kane, and complained. And Kevin Kane laughed at them. And so they went to Deidre Daley, who was a U.S. attorney. She's a big pal of Bizzuto. Next thing you know, the FBI shows up at my house in January 2017. I mean, all you got to do is connect the dots. just laughing, and you know, and then oh my God, we got a trial coming up in September. What are we going to tell the judge? Oh, my client's incompetent. Oh, and the judge says you're right. Let's have an evaluation. That's burned 120 days. And what was the purpose in law on that? And did the judge even follow the law? Did he say, is there probable cause under Dusky that he's incompetent? No, he just listened to Alice complain about Michael Volpe and the fact that I talked to him. And oh my God, the guy must be have mental impairment, so we better stop everything. Oh, come on. This is just getting ridiculous. And, but anyway, what I really like is if you and Mike can talk, and, you know, I sent a note to Mike this morning. I said, why don't you ask Kelly for the everything that's been filed since October of 23 and the judicial orders. And, you know, and just to piss her off, because she's thinking, oh, well, you know, I mean, she hasn't even looked at the file. And, oh, by the way, your reference case on that is Shepard v. Maxwell. I think you know it.
Uh-huh.
And what did you say something about an interested press is a handmaiden to proper administration?
Justice Powell. That's right. Shepard v. Maxwell.
Was that Powell?
Well, it was Powell. It was about open courts, open information, about the search for truth.
Yeah. Well, that Powell was from Richmond, by the way. He was a partner at Hunter and Williams. And anyway, good old Virginia boy. But anyway, so that's the fun on that. So if you really think of some things to needle these guys with, because Harmon, I think the reason he doesn't want to touch it, he's been threatened. I think when he dropped the bond from 750 to 75,000, he got his dick smacked, and then Doyle is looking at this as an opportunity to kick it back up, because he knows that Harmon got dumped on, and that's why Harmon won't hear it. He'll give it to Brown because Brown's being told what to do. I mean, Brown denied my motion for declaration of essential elements of the crime, and Harmon never issued an order on the motion for particulars, so I could find out what the fuck I'm being charged with.
Well, you do. Did you see our piece about Mike's conversation with Eugene Volokh, where he said that there was palpably enough for there to be a jury question of whether they constituted a true threat. The statements in the affidavit.
The only thing I remember from that thing is Eugene's word salad was something like, what's in the arrest warrant says it's something like the threshold for a true threat. And I just laughed. They said there's no definition. There's no definition of a threshold.
Well, do you think you've read Eugene? You've followed him for years as a journalist, a blogger, and a follower of the First Amendment.
I can't hear. I can't hear you.
You've read Eugene for many years. You've followed him as a journalist, a blogger, a follower of the First Amendment. What do you think is going on in his head here? Is this just politics that he doesn't want to get involved? Is it because of the facts of your case, because of the anti-Semitism, because of the ADL?
No, it's the ADL. Okay, Eugene Volokh is in that job as this big professor and champion of free speech. He's never had a client. Okay, he's in that job as a professor because of the ADL, all right? He's not there because he's a brilliant jurist, all right? I mean, and he has a job to do, and he's not going to come out and say that, oh my God, Connecticut is doing this wrong, and shitting on Jews is protected speech. No, he can't. Okay, so it's irrelevant when he says, oh, this is a threshold for true threat. No, it's not, because to get to true threats, you have to go through incitement of violence. Because true threats are a subset of inciting violence. Okay, so you have to go through Brandenburg first. Now, if the KKK boys can be on the evening news in Cincinnati Cincinnati in white hoods and in white gowns with guns chanting about killing niggers, okay, that's not a true threat. That was for advocacy of violence, all right? And you want to get through NAACP, Claiborne Hardware. We're going to break your fucking necks if you buy from those people. Okay, standing right in front of the crowd, and the Supreme Court said, not political. Okay, and what is the blog? 100% political. Family court is evil. It's not part of the American fabric. And what do? They come down on it because the blog says it's all by Jewish design, which goes back to the Gospel of Mark and Matthew, which why do the Jews give their wives bills of divorce? Because they have hard hearts. All right? Yes, wonderful.
All right. Well, let's go back to Eugene Volokh and say the guy's clerk for Sandra Day O'Connor. Right. Wait. The guy clerk for Sandra Day O'Connor. The guy has been a decorated historian and legal scholar of the First Amendment and the Second Amendment. One of the foremost libertarian scholars. Are you saying that it's his work for the last 40 years, 50 years has been irrelevant?
When he comes out and tells Mike that what's in the warrant meets a threshold for a true threat, there is nothing to support that. There is no threshold. Okay? It is...
so he's legally wrong, is what you're saying?
No, I'm not saying it's legally wrong. I'm just saying he used words that have no definition, which is a hallmark of Jewish word salad. Okay? Doesn't it sound wonderful? It meets the threshold. Oh, why? Wait a minute. What's the threshold? Where do we find it? How is it defined? Good luck. And the problem is the blog has an about page which everybody ignores. Okay? Every time I bring it up, oh yeah, I saw it there. Yeah, what? The about page lists all sorts of Supreme Court cases that basically allow written word, which is a protection of discussion. It's discussion, okay, which is protected under the First Amendment. And it just doesn't step outside the bounds. I mean, in order to make a true threat, it has to be, I'm trying to remember, I think in Virginia v. Black it had words, the most recent words on true threat. It has to be direct, imminent, has a likelihood of succeed, da-da-da-da-da, okay? And then what Connecticut's trying to play is, well, if he had an intent to inflict substantial emotional distress, then he's guilty of 18 felonies. Well, wait a minute. If you're having a political argument, I'm sorry, is there a substantial infliction or substantial emotional distress component to limiting political speech? No. So, I mean, the stalking statute, again, is ALI, which is a bunch of Jews, and, and it was struck down in Illinois, and it was torn apart in D.C., and, I'm sitting here going, oh, so Illinois basically struck it down before Connecticut even adopted it. Oh, I get it. So Joette Cass and Damon Kirschbaum are ALI people, and they got this law passed in Connecticut so they could resurrect it and, give it another shot. All right? And that's what they're doing. This has nothing to do with the First Amendment. This has everything to do with, the Jews writing, what do you call it? They're writing penal codes to corral the goy. We can't have you standing, with the Palestinians protesting outside the Israeli embassies in Washington while Palestinian children in Gaza are being killed with American weapons. You can't do that. That's terrorism. We'll arrest you all. I'm sorry, we're being manipulated, and this is a game. So unless somebody So, wake up, man.
Okay.
We're living in a horror show.
Yeah. So, all right. Well, I'm gonna take a look for you. I'll try and reach out to your lawyers and see if they'll say anything to me. I doubt they will, but I'll keep on asking questions, and I'll put together some media. Okay. And I'll obviously get out there your views on our friend Eugene and on I guess the Waldorf pedophile bastion of Connecticut, which is
Have a ball. I mean, and if and leave your deadbolt unbolted because the SWAT team will just rip the door jamb out.
Yeah, I don't know.
Pay for the repairs. But no, this is what we're up against. But if you can ping on Dennis and Kelly for me, I'd appreciate it.
No problem. I want to get to the bottom of it.
All right. Have a good day.
Have a good one.
See you.
Will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. To refuse this, thank you for using Securus. You may start the conversation now.
Hey, Paul, how are you?
Oh, just ducky. Do you have a Merry Christmas?
I did. Everything was nice. We had a very nice Christmas. It was good. It was good. Yeah.
We had an escape plan. We were going to sneak onto the back of Santa's sleigh and go off with the reindeers, but he couldn't get down the chimney to the prison because we don't have a chimney. Oh well, spoiled plot.
Oh, that's
anyway.
funny.
Hey, I have a meeting with Kelly and Dennis this afternoon at 1 o'clock. I was calling to see if you had any inquiries for them.
Oh yes, have them. I sent them a whole bunch of email questions before, and if I'm going to talk to them, I'll have them talk to me. If they don't want to talk to me, let me know why, and have them give a reason why they don't want to talk, because you want them to talk, or at least give me a no comment.
Yeah. Well, they've both been instructed to respond to you and Mike, but there's a good one. This supposedly nasty back and forth email from Doyle opposing the bond reduction. Mike had asked for it, but Kelly wouldn't give it to him. So I told Kelly, I said, well, bring me a copy when you come see me this afternoon. And she said, well, I'll bring a copy, but you can't have it. And I'm like, well, you better bring a citation saying why not.
Yeah, that's
because
crazy.
when Doyle hit the send button, he put it in the public domain. That is not privileged information. And so, I mean, I could see if it had something to do with the plea agreement, but not a bond reduction. I mean, he's just telling the lawyer he's going to ask to raise the bond. Okay, so what?
How did you get more dangerous by being incarcerated? Isn't that an indictment of the Connecticut system?
Doyle is a bald-headed little shit doing exactly what Katz wants. There. Stop asking me stupid questions.
No. But I'm telling you, remember Murder in the First?
No, I understand. You cannot move the state cannot move to raise a bond. It has to be, they have to move in good faith to raise a bond.
Yeah.
So
what's the good faith? What's the good faith basis?
There is none.
Well, no. I think there is. Paul. If we're searching for a good faith basis, I think that the good faith basis is the same one as in Murder in the First. Is that you were not as dangerous as you were before you were placed inside the Connecticut system, and it's an indictment of the Connecticut correctional system that you've become far more dangerous by being housed inside.
Come on. Now you're applying logic. I mean, if there was any danger, wouldn't the state have moved to take down the evil blog?
Yeah, well, they can't do that. That would smack of the First Amendment. They don't want to get that close. They can come in from the side on the First Amendment and chip away, but if they want to go straight down the middle, they might get smacked down. So there might be a popular uproar. So.
Yeah, right. Connecticut. Everybody's too busy snorting coke
And trafficking children, right?
Yeah, that's all they do. The Constitution doesn't apply here. Oh, by the way, I found out out of the blue. I think it was back in 2011. This guy named Turner, who the feds had nailed for making nasty statements about judges on the Heller case in Chicago.
Okay.
And, well, Connecticut arrested him. I guess he was in jail serving the federal time. And Connecticut came and arrested him on, he made comments to then State Senator McDonald, who had raised a bill to allow what it was statutory requirements for auditing of parish financials in the Catholic Church, which just exploded into who the fuck are you? Because, separation of church and state, they can't do that. But anyway, he had said some rather American things about McDonald's conduct, and supposedly he was dragged before a jury. He had to fire his lawyers. He handled it pro se, and the jury acquitted him. But you might want to look that up. It was Dave V. Turner. I think it was in 2011 was the verdict. I think they charged him in 2009. And it's just a trial case. It never went to appeal, obviously. But now we're getting a pattern here within Connecticut, because in State v. Liebenguth, the state Supreme Court says white people calling black people fucking niggers is illegal. It's under the fighting words doctrine. But of course, black people can call white people whatever they want. Anyway, but there's a pattern here. And it's all coming from the judiciary. McDonald was chair of the General Assembly Judiciary Committee when it happened, and now McDonald is on the Supreme Court, and he chairs the Criminal Justice Commission, so he oversees the prosecutor who's prosecuting me, and McDonald's a blog star. And in fact, the blog was quoted by every TV news station when they tried to put McDonald as the Chief Justice. But anyway, so it's just kind of funny. I mean, this thing just keeps rolling. But I just found out about that Steve V. Turner the other day. So I think the New York Times even wrote about it.
Oh, really?
Yeah. So I guess the thing I asked for you, I don't know, Turner's probably out of jail by now. Maybe he was living in North Bergen, New Jersey at the time he got arrested by the feds. Maybe you can reach out to him, and he might have found some helpful associates during this time. I don't know.
Okay.
But it's interesting though. All of that, because Turner had a blog, and he was arrested by Connecticut for his blog post. But that was before U.S. v. Cassidy down in District, Maryland, which the Department of Justice didn't appeal. They agreed to it. They said, yeah, you're right. We can't run around arresting everybody for saying, political shit against public officials on the internet. And I think what's happened is because DOJ didn't appeal that back in 2011, and it stood, and Eugene was in on that as well. Everything was fine for a while until Alonis came along, and everything on Facebook was a crime. And then I think what's going on, I can tell in Connecticut, is they don't like that. They don't like the fact that the federal government agreed with Cassidy, and they're writing their own laws, and for their own purposes, i.e., Jewish, to silence the goy. And oh, by the way, there is an 83-page file that you can probably find. It's a PDF file in the legislative history of this Connecticut stalking statute, PA 21-56, and it's like 84 pages long. But evidently, Colangelo, the guy who was told by Judge Carroll to initiate this investigation back in 2020, he was testifying or appearing before some committee telling the legislature why they needed this law. And he basically spells it out. We're going to go get anybody we don't like saying shit anywhere. And he even talks about extraditing people. So, I mean, it's like a conspiracy to create a law which will give them justification to go out and arrest anybody in the United States for something they don't like. But you might want to find that. I'm sure there's some gems in there. I'm sure there were some people who came and said, no, you can't do this because, if you can't apply it to speech or something like that, or somebody's going to say, oh, don't worry, this is just physical conduct. This is nothing to do with speech. But anyway, I've asked my lawyers to bring me a copy of that, so you might be able to find it. It should be on the Connecticut General Assembly website. They usually have archives of all that stuff.
Okay. What are you doing at about 11:40, 11:45? Can you get back on the phone? Because I'm going to be on with Volpe for our podcast. You want to call in?
11:30. No, the phones are off then.
Okay.
So, I'll give it a try. Sometimes they don't turn them off, but usually they turn them off because there's somebody sitting, in front of some console looking for red flags on phone conversations.
What time?
Right now,
what time are the phones turned off and on?
I think they're on in the morning, like 9:15 till 10:45, 11 o'clock, and then they go off until what time is Rick's turn? Like 1:15 in the afternoon.
Oh, okay. Because we're taping between about 11 and 12:15 Eastern time.
Yeah, I'm pretty sure they're off during that time.
All right, maybe we'll maybe we'll figure out another time we'll tape during during when you could call. We'll have you call in live.
Yeah. Hey, the other thing is, have you taken any time to look at this jurisdiction issue?
I am, and I think we're going to talk about it today. I think we're going to talk a little bit about it today.
I mean, if you're going to say somebody stalked somebody, well, then it would be a stalking crime in Virginia, which it's not, because Virginia stalking is just physical conduct in a public place. And, every time I raise it, everybody's like, oh, you're stupid. You don't understand. Yes, they can have extraterritorial operation of their laws. And I said, what about the full faith and credit clause? And then, nobody wants to talk about that. So, I mean, the only thing Connecticut's trying to do is to dissolve the states. If I don't like something you said, wherever the fuck you are, I'm going to arrest you. And, but anyway, if you can dig up Turner, find the legislative history file, and then do some digging on jurisdiction and extraterritorial operation, full faith and credit clause, I think that would keep your plate full for at least 15 minutes.
Yeah, I'll take a look.
And I will definitely take notes on whatever Doyle said in this email and give you a call.
Yeah, this is going to be pretty fun, actually. Yeah, that's one thing you could tell your counsel. They want to know you want to know about the third party communications, or I want to know about the third party communications that they've had with Jack Doyle, and Jack Doyle's stated basis for raising your bond. I think that's the thing, the absurd thing to tell a story about how crazy Jack Doyle is, and everyone seems to think that this is normal. Right? I just wrote an article about California being the land of the fruits and the nuts.
You have 1 minute left.
And the article was about how Lex Luthor in 1978, the Superman movie, had the far-fetched scheme that California should be bombed into the ocean. And you think as the days pass by, it gets more and more plausible and more reasonable. I think the same thing might have to happen with Connecticut.
I think anything that you do when you talk about Doyle is say that he's doing it in the name of the people of Connecticut.
Yeah.
Because he doesn't realize that's what he's doing.
Yeah.
He is doing Katz's agenda.
Yeah.
But anyway, the call's gonna drop. I'll catch up with you when I can and let you know. But have a good one.
All right.
Like I said, hi.
I wanted to get an update on the Paul Boyne case, but I want to do this from now on. Before we update on the Paul Boyne case, let's just really quickly summarize it. He writes on a blog called The Family Court Circus. He exposes a lot of judges in Connecticut. They don't like him. From time to time, he uses language that maybe he shouldn't have used. Neither you nor I believe it is illegal. He is sitting in jail. One person who thinks it might be illegal is Professor Eugene Bollock. He came up with a list, maybe not exhaustive, but here are some of the reasons why Professor Bollock thinks he should be in jail. In the crosshair sight of a firearm, referring to a judge. The judicial vengeance of Judge Mokashir begs a 50 cal to the head. Talk of, quote, assassinations and a 50 cal ammunition. The item listed in 6, is she begging for a 308 shot to the head through 2 panes of glass from an oath keeper concealed in the wall? I'm sorry, it's funny. How do you think it's a true threat if you're laughing when you're reading it? All right. It's funny. All right. A quick 50 cal to the head delivered through the back of a window of her car. Worthy of a 50 cal to the head. The Molotov cocktail stuff. And he goes on. There's some, that's the stuff that Professor Bollock thinks he may have done that's illegal. The term is true threat, meaning that a reasonable person would believe that it's an actual threat. I don't think any actual person thinks that Paul, who was living in Virginia at the time, was really going to fly or drive or walk or crawl or hitchhike to Connecticut and kill any of these judges, but they're all pretending like he did because he really was exposing them. He is, in my opinion, a political prisoner. I think you agree. But the latest update is he fired his old court-appointed lawyers. I like his new lawyers because they give me stuff, but maybe that's not really a good reason to like them. But they filed something, and you can see it here, motion for modification of bond. I thought it was an excellent motion. The 3 main points were, 1, he's not dangerous. 2, he'll show up to court, and they pointed out that he even showed up to his divorces all the time. 3, he's indigent, so he can't pay this anyway. So you should reduce it. Sounds good. Paul disagreed. Kelly is one of his lawyers. Kelly is just too timid to play Jack's game. Jack is the prosecutor. Will probably end up on the trash heap with Jen and Alice. That's his former lawyers. Kelly is refusing to execute client direction already. She thinks she's going to plead a bond motion before Brown Man. That's what he refers to as his judge in black robe on January 3rd. But I already have a motion to disqualify the ape, which she tries hard to ignore. She refuses to demand a status conference before Harmon. Kelly's plan is to discuss with Dennis. I don't know who that is. Then schedule
Dennis is the co-counsel. They're two.
That's the co. They're the two counsels.
And Paul actually thinks that he's a distant cousin from Ireland.
All right, so he goes on. Does he have a point here? I'm not sure why he thinks that she can argue in front of any judge he wants. And, should she wait until this other motion is heard? Does he have a point? But look, the larger point is, if your client says something and they insist, you have to do it.
No, Not at all. No, there are two things there. One is that there are certain points in the representation, where your client says, I want to do this, I want to, and you have to do it. But there are other points when it comes to points of legal strategy and specialized legal knowledge, where the attorney is given the ability to exercise professional judgment. Now, it comes to the point where the attorney acts perilously at that point because they can put themselves at odds with their client. And one of the reasons for withdrawing as counsel is because there is a total disagreement as to the representation, and there's a loss of confidence in professional judgment and everything else. The problem we have here is that Paul is well versed in everything related to his case, legally and everything else, factually, more so than any attorney that could ever come onto this thing. And he believes he knows more than the lawyers. And in many cases, he kind of does know more than the lawyers on certain points. But in other points, you need a lawyer to go in there and basically work it for you. And he doesn't think he has anybody that can work it for him. He thinks the new lawyers they gave him, they're good, but they're like they're like wolves. They're sheep being fed to the wolves. They're young and they just don't know that the whole thing is against them, and that's what Paul's belief is. It's that this is the Joette Katz show, and everybody else is dancing to the music.
What are they supposed to do if they believe that the thing is rigged? What are they supposed to do? How are they supposed to act differently?
I'll tell you what. He has a jurisdictional point that's very interesting. If there are 3 different occurrences with 3 different judges, how's there one trial in one place?
Correct, and none of the 3, and the point
and that hasn't been raised yet. That's important. The other jurisdictional point is how the hell did he get from Virginia to Connecticut? How the hell did he get there for a speech crime? It doesn't look like that there was jurisdiction for that as well. Those are very basic issues. And the first thing you talk about in law is jurisdiction. Day one of every
they can file those things. Is she wrong to try to get his bail?
I think she's smart trying to get him out. I think you do better trying to fight from outside than inside. And Paul says it. You give me 8 to 10 hours on a computer outside of this place, and I'll be able to prove that the whole case should be thrown out. That I'm legally innocent.
Look, Paul is a very difficult client, no matter whether you're a crap attorney or you're doing your best. And
if Eugene Bullock took the First Amendment issues on his case, he would argue with Eugene, telling him that he's wrong. That's how Paul is. That's just how he is. But I think that the bigger point of this, and I'm going to use a great New York Yiddish term, I think that the Connecticut authorities have elevated kvetching about the Connecticut judiciary to criminalization, because basically that's what Paul's been doing his entire time on the blog, and now from prison he just kvetches. That's what he does. He complains and complains and complains and complains, and it's at a new level of criminality. You can't complain about the judiciary. You can't kvetch.
That's true. Though, as I said, the real issue is that he's exposing their malfeasance. They're obsessed with how much exposure they're getting. He's very exact. He seems to know things that people shouldn't know. They don't know how he knows them. And I think they also want to send a message that others will be treated the same way. But you're right. This is a patently ridiculous prosecution. No one thinks that him joking about 50 cals is a real threat. Nobody actually believes this. You are perverting the First Amendment. You are making him into a political prisoner. But as a result of my coverage, your coverage, Frank Parlato's coverage, and a few other people, I think it's in some ways backfired because this has come out in a way that no one ever expected. Now,